This is a presentation on the Privy Council's judgment without law, imported Australian doctrine, cancelled parcels, and the erosion of property rights. It's a presentation by Jack McKenna of Land Data Plus. It's a book review, His Majesty's Privy Council judgment that betrayed justice, imported Doctrine Over Enacted Law by Vance Chitolie. The book is available on Amazon.com. The Privy Council judgment that betrayed justice, imported Doctrine Over Enacted Law, how law was replaced with fiction. Unspeakable pain and suffering. This book by Vance Chitolie is born out of the unspeakable pain, suffering, and lasting harm inflicted upon his parents, both now 84 years old, and upon their family and himself by the manifest injustice of the judgment handed down by the Judicial Committee of the Privy Council. What was lost was not only land. It was dignity, it was security, it was faith in the rule of law. The judgment did not merely deny a legal claim. It extinguished decades of lawful possession, displaced statutory command, extinguished statutory protections, supplanted Parliament's enacted law with imported foreign doctrines, and imposed costs on the appellants whose rights under the St. Lucia Land Registration Act, the LRA, were erased by the wrongful importation of Australian jurisprudence. In the late years of his parents' lives, his parents have endured an ordeal no elder should ever face: the erasure of their rightful land and the destruction of their legacy by the JCPC judgment that undermined the very statute it professed to uphold. What should have been a season of peace and dignity has instead become one of grief, dislocation, and hardship, material, emotional, and generational. Truth Obscured. This book is a testament to truth obscured, law defied, and the human cost that endures beyond the courtroom. It chronicles not only the statutory violations of the LRA embedded in the JCPC judgment, but also the lasting generational harm it has inflicted. It is a call to confront the collapse of fidelity to law at the highest level, to restore the primacy of enacted law, and to ensure that courts do not become instruments of dispossession, erasure, and despair. May this record stand as both testimony and warning. Justice denied in one case cast a shadow upon all. A single failure of the courts, if unchecked, becomes not a precedent of law, but of impunity. This is more than a miscarriage of justice. It is a breach that undermines the very integrity of justice. A judgment that displaces law and erases rights does not only fail justice, it also endangers it. Injustice delivered by the courts is among the most harrowing forms of betrayal. This book presents a profound exploration of how courts, tasked with the noble duty of upholding justice, can falter and become an instrument of oppression. This book challenges the reader to question, to empathize, and to act. May it remind you of the fragile line between justice and injustice, and the role we all must play in ensuring the former prevails. When justice becomes betrayal. Justice demands fidelity to law, to fact, and to the rights of those who rely on both. But what happens when the final judgment of the highest court, the last refuge for the wronged, becomes a very source of their harm? What happens when the judgment of the Judicial Committee of the Privy Council, the JCPC, abandons law, ignores fact, and delivers injustice under the seal of finality? This book confronts that question. It documents a profound miscarriage of justice and JCPC appeal 2023, UKPC 43, Francis Chitolie and Vance Chitolie, the appellants, versus the St. Lucia National Housing Corporation, the respondent. A ruling handed down on December 5th, 2023, dismissing the appellant's appeal with costs. A judgment so broken, it demands account, not merely for what it decided, but for how it reached that decision. How did the highest court deliver a ruling so untethered from statute, so indifferent to fact, and so destructive to the rights it was bound to protect? This book answers that question. For 14 years, the appellants pursued justice. Instead, what they received was a final blow, a judgment that extinguished their vested rights expressly protected by statute. The JCPC supplanted St. Lucia's Land Registration Act, the LRA, with imported foreign doctrine. Imported unlegislated Australian Torrens doctrines, substituting statute with fiction, founded on a phantom deed, title to a defunct, expunged, and legally dead parcel, substituted the very subject of the appeal, created a case that respondent never brought, resurrected a defunct, expunged parcel, ruled on land west of a fixed natural boundary, yet by its order granted land east of it, modified its own circulated final ruling. The JCPC issued a final ruling that materially diverged from its own circulated draft, without explanation. It was not justice. It was the collapse of the rule of law. This is the defunct, cancelled, expunged parcel claimed by the respondent and elevated by the Privy Council, the judgment in 2023, 11 years after its cancellation. This is the clearly compromised record accepted by the domestic courts against the appellant's land. It began as a lawful claim. What began as a lawful claim, rooted in possession, anchored in a court-ordered survey, and protected by statute, was extinguished by reasoning foreign to St. Lucia's law. This was not merely an unjust outcome. It was an unjust process. It was the collapse of the rule of law, a judgment without a claim, a judgment without title, a judgment without lawful foundation. With a single fateful phrase, subsequently became the judgment resurrected a defunct parcel, cancelled, expunged, and erased from the land registry, and judicially transformed it into the appellant's surveyed land. The judgment rewarded a phantom claim, awarded land never claimed, imposed costs without justification, extinguished rights expressly protected by statute. The JCPC evaded the question that undermines its very foundation. How does a defunct parcel west of a ravine become surveyed land east of it? The judgment was silent. It had no answer. This is not precedent. This is peril. Delivered from the highest bench, this ruling sets no legal guidance, only a warning. It elevates finality over fairness, legality over justice, and judicial decree over statutory command. This book is a reckoning. It lays bare how the judgment of the final court, the ultimate guardian of justice, delivered a ruling that abandoned the governing statute, erased statutory protections, imposed an unlegislated Australian Torrens doctrine, and collapsed the distinction between fact and fiction. The book is structured in 4 parts. It charts the judgment's descent from law to the betrayal of justice. Part 1 dissects the flawed domestic rulings and the fictional claim upon which the respondent's entire case was built. Part 2 exposes how the JCPC judgment displaced St. Lucia's Land Registration Act with imported Australian Torrens doctrines, extinguishing the appellant's statutory overriding interest. Part 3 reveals the judgment's internal collapse, its silence on the appellant's court-ordered, surveyed parcels, its resurrection of a defunct parcel, its substitution of the appealed subject, and its disregard of the appellate record. Part 4 confronts the implications, legal, constitutional, and moral, of a judgment that cannot stand. It demands accountability, redress, and the restoration of justice. A reflection on the broader implications. The book concludes with a reflection on the broader implications of the JCPC judgment, emphasizing the urgent imperative to restore justice, not only for the appellants, but for the integrity of the law itself. In every way that matters, this judgment failed the law, failed the facts, and failed justice. This book names those failures for what they are: a betrayal of justice and a judgment that did not interpret the law, but displaced it. A judgment that did not apply statute, but cast it aside. A judgment that did not safeguard rights, but extinguished them. This was not merely the conclusion of a single case. It was the collapse of a final judgment, an abandonment of law and of public trust. In the shadow of final judgment, this is a denial of property rights that triggers the right to compensation, not only as an undermining of the fundamental purpose of appellate review, but also under international law, particularly Article 17 of the Universal Declaration of Human Rights, which affirms the right to own property and prohibits arbitrary deprivation of it. The JCPC judgment's miscarriage of justice. Delivered in the sovereign's name, it displaced statute with fiction and extinguished vested statutory rights. This was not mere judicial error, but a failure of the Crown's system of justice. Lord Denning on overriding interest. Lord Denning's view on overriding interest was disregarded. Sections 28F and G of the St. Lucia Land Registration Act mirror the protections embedded in the former Land Registration Act of 1925 in the UK, explained by Lord Denning in Strand Securities Limited versus Caswell in 1965 to WLR 958 at 970. A person in actual occupation is protected. He can stay there and do nothing, yet he will be protected. The purchaser must inquire at his own risk. Accountability by the Crown. Where courts have closed their doors, the Crown remains accountable in both law and equity to provide the redress that justice demands. From the Earl of Oxford case in 1615 to M versus Home Office, 1994, the principles are consistent. Responsibility cannot be severed from the Crown in law or in equity. An injustice pronounced under royal authority endures as a stain upon the Crown's justice until it is redressed. Across societies, there are moments when justice falters, when judgments bound to uphold rights become the very agents of their destruction. This book chronicles one such moment, a judgment of the Judicial Committee of the Privy Council that delivered harm, unchecked, unchallenged, and unconscionable. But injustice, once exposed, can be confronted, and once confronted, it can be undone. A final judgment that was meant to deliver justice. See how a final judgment that was meant to deliver justice instead delivered harm, and why that ruling must not stand and cannot stand. In the matter of land and law, let it be recorded. No court judgment, however high, may confer what is not owned. Yet the JCPC judgment declared otherwise when it conferred land to a party that never claimed it. No court stands above the law. But this Privy Council judgment acts as if it does. The Privy Council judgment, pronounced in the Sovereign's name, displaced the statute enacted by the Parliament of St. Lucia, the Land Registration Act, with imported Australian Torrens doctrines that were never legislated locally. By judicial substitution, the court extinguished rights guaranteed under St. Lucian law. This is ultra vires, inconsistent with the principle of parliamentary sovereignty and destructive of the rule of law. When law ends, tyranny begins. John Locke, 17th century British philosopher. Conclusion. The Privy Council judgment displaced St. Lucia Parliament's enacted law with imported Australian doctrine. The ruling extinguished vested rights secured under law. Justice was not upheld, it was betrayed. Where courts have closed their doors, the Crown remains accountable in both law and equity to provide the redress that justice demands.